Good morning, everybody. Thank you so much for attending my class today. My name is Romy Jurado. I'm an attorney here in South Florida. My law firm, it's called Jurado and Associates, and we practice in different areas of law. We deal with real estate, of course. We deal with litigation, probate, estate planning, immigration, trademarks, and let's see, what am I missing? I think that's about it. And today's class, it's going to be focused on how to protect realtors from potential litigation and what measures to take if a litigation were to arise. We live in a very litigious society. Anybody can file a lawsuit. You don't need to really submit proof to file a lawsuit. You can just start it and then people get to fight it out in court. So because of that, it's always important to think about protection, because the moment that you go into business, you're basically exposing yourself. And as realtors, you guys have a lot of communications with different parties and you're involved in various transactions. So the exposure only grows. I like to make my presentations really interactive. So if you have any questions, please feel free to put it in the Q&A or in the chat, and then I can answer all your questions. After today's class, I will send my presentation, my PowerPoint to everybody that registered. And I'm hoping to record this meeting. And if it comes out good, then I'll be glad to share it with everybody. I will also, let me see if I can put my contact information here in the chat, so you can contact me after the class. Give me just 1 second. Okay, well, there's a beautiful picture of Miami. And again, our law firm is called Jurado and Associates. And as you see in the bottom, we help with business law, real estate law, immigration, probate, estate planning, and of course, litigation. So realtors are target of her lawsuits, right? So a common lawsuit scenario that I actually see a lot involves a buyer of a property before suing the seller and the seller agent for failure to disclose defects in the property. In some cases, the buyer also sues their own agent and the transaction. So they blame the realtor because the realtor didn't see something or didn't disclose something that maybe the realtor didn't even know. So the lawsuit alleges not just negligence, but also alleges that the seller and the agent conspire to keep defects hidden to facilitate the sale at a higher price and earn a higher commission. Sellers need to do the seller disclosure. If you know anything about the property that negatively affects the value of the property, then you also need to disclose. Otherwise, they can actually file a lawsuit and say that you were in on it with the seller in order to get a higher price and then sue you and your broker for that. So at the beginning of any transaction with any client, you want to make sure that you explain your relationship. As realtors, you can be a transaction broker, single agent, or fiduciary, which is kind of like what I am when I represent people. I'm a fiduciary. You can have no brokerage relationship. So this is something that you need to make sure that it's written in the beginning. Now, the statutes say that transactions default to transaction broker. However, my advice is always make them sign something that says that they understand that you're a transaction broker, so that way they understand your limited duties towards the client or the customer. And that if there is no brokerage relationship, you want to make sure that you make them sign that as well. It's so important with anything in life to have everything in writing, because when you just tell them, they will deny that you told them, and then it's your word against them, the lawsuits that's going on, and it's not a nice scenario. Whereas if you have it in writing, it's something you can show to the judge, and then there's less questions about it. So knowledge is power, of course. The most common claims made against real estate professionals are lack of information, okay? And we will talk about that in a minute. And then you want to make sure that you also have insurance, which is also very important for realtors or for anybody really that's going into business. And I'll talk about that in a minute. So failure to disclose, as I was mentioning to you all, it's the most common thing that we see nowadays, because everybody is super, I guess, excited to buy a property. They get their offer accepted, they close because it's really hard to find property. And then after, they're like, oh, well, this is not right, this is not right. Sometimes people even buy property without inspection. So you want to make sure that everything that you know of is disclosed and that the seller is disclosing. So failure to disclose. Clients who discover defects after signing the papers will be quick to blame the real estate agents. Every damage and every defect found on the property should be fully documented. Defects can include construction issues, leaks, noises, improving the property without permits, When a client sues a real estate agent for failing to disclose a property defect, they have to prove that the agent knew or should have known about the defect and did not disclose it. Be sure to perform a thorough inspection. All buyers should be doing an inspection of the property, and they should sign a statement that they are aware of any issues, so they cannot claim that you failed to disclose. A common thing that I see happening is of course, the agent, the realtor, says to the client, to the customer client, listen, there is a property inspection company that you can hire. Be sure to do that. And then they go and they hire the property inspection company, but then they get the report. They don't even look at it, right? And they forward it to the agent. And so they expect the agent to review the report and to tell them whether there's something wrong or not with the report. And then I see the agent actually replying back and saying, no, there's nothing wrong with the report. Unless you are a licensed contractor, a licensed roofer, a licensed inspector, you should not be making statements regarding the condition of the property. If the buyer went ahead and obtained a property inspection report, they need to read it. If they have questions about it, I'm not the right person to discuss it with. I'm a real estate attorney. I don't know about construction and stuff like that. I know about construction law, but not about real construction and how it's done. So what I do to cover myself, because I can also be potential a lawsuit, is I put them to speak to a contractor. They get the report and they're wondering, is it really going to cost me this much? Is this property worth it? I put them to speak to a licensed contractor, 1, 2, or 3, so they can get different quotes. The contractor will tell them, well, we can fix this. It will cost you this much, or this is not really a big issue. This is just whatever. I actually have contractor friends that I'm like, listen, what I need you to do is whenever a buyer asks me for my opinion, I want to put them together with you. You explain what you know, and then hopefully you get a client out of it. And that's it. Now I've released myself from liability. The buyer has some further understanding of what they're getting themselves into. But you're not assuming any responsibility. When you review a property inspection report and you reply, there's nothing wrong with it, you are assuming liability regarding that inspection report. So be really, really careful with that. And I see that happening a lot. So my recommendation is don't do that. Okay. If there is a property inspection report, the buyer needs to consult a contractor. They need to deal with it and figure it out. All right, let's keep going. Next, breach of duty. This is so important, okay? This represents one of the most common lawsuits against real estate agents. You know you must always act in the best interest of your client, as clients place special trust in real estate agents for your expertise. And as a real estate agent, you're held to a higher standard of honesty and full disclosure. Any breach of this duty, whether for negligence or intentional action, is subject to the risk of a lawsuit. Always document everything and be honest at all times. Another thing that I see a lot is agents, of course, they're put in the middle between the mortgage lender and the client or the customer. And they're put in the middle to basically send the tax returns, to send this and send that. That is very confidential information. And if you're put in the middle to send this information, now you need to make sure that it's properly safeguarded. So if somebody has access to your email, you can be held responsible. So it is extremely important, okay, to please always try not to get involved in the middle. Put everything in writing, because you don't want them to hold you responsible and say that because of you, they obtained, whatever, they disclose information that they shouldn't have. So breach of duty, and it also depends on the duties. So depending on the type of relationship, whether you're in a transaction brokerage or you're a fiduciary duty, your duties are increased. So you want to make sure you understand what duties you owe to the client, and then you go from there. Breach of contract, right? So when a client claims a real estate agent did not perform under the terms of a contract, you need to seek legal action, because now they're going to try to come against you. One of the most common reasons for breach of contract is failing to comply with timeframes stated in the contract. A breach of contract claim is often made in conjunction with claims of negligence, fraud, or breach of duty. It's important to examine every aspect of your contracts with an attorney to ensure appropriate information is accounted for and accurate. Additionally, be sure to take time with each client to advise them on the terms of the contract properly. Now, be careful with this. You can read them, real estate contracts, the forms, you are able to read to them. But I would not go as far as explaining if there's something unclear. If it's a form contract, then it's all there, they can read it. But if they have specific questions regarding structuring and timing and whether they can add additional clauses, My advice is have them consult with a real estate attorney, with a real estate litigation attorney, with a real estate attorney, with us, so that we can advise the client. Okay, be really careful, because I have seen lawsuits where the client says, well, my realtor told me this, and my realtor told me that, and this is why I did it this way. You as realtors can find the property and tell them about the property and price and the location and things like that, but don't assume liability by explaining additional things, particularly if it's a different type of transaction. Like if you're doing a contract where somebody's buying a property and selling it right there at the closing table, you know, A to B, B to C transaction. If you're dealing with commercial property, please, 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 even if you think it's a standard contract, especially with commercial property, you should hire, well, not you, the client should hire an attorney to properly advise them of the intricacies of commercial property. And foreign buyers, you know, foreign buyers, they assume that real estate agents are attorneys. I see it all the time. Have them consult with an attorney if there's something they don't understand, especially buying property here in Florida. If they're buying in their own name, now they're going to be subject to a 40% state tax. There's also FIRPTA implications. FIRPTA means that at the time of selling the property, if a foreigner has it under their name, there's going to be a 15% withholding of the whole sell price. And a lot of clients, you know, they freak out when they find this out at the closing table, and they blame the agent. Well, the agent didn't tell me this. Well, he didn't tell me that, or she didn't tell me this. It's really not your job to tell them this. They need to hire an attorney. So if you're dealing with foreigners, advise them to contact an attorney so that they can understand the contract and the intricacies of investing in real estate in Florida and how to properly structure. If you're dealing with commercial property, same thing. If you're dealing with multi-housing, if you're dealing anytime, just have them talk to an attorney to limit your liability. This is what we're trying to do. We're trying to limit our liability, in your case, yours, so that the client cannot say, well, you know, the realtor should have told me this, and then put it in writing. Okay, there have been instances where the buyer was advised to hire an attorney, but of course they didn't, and then the transaction ended up really badly, and now here they are blaming the agent, right? Why didn't you tell me this? So the agent had an email where she actually wrote, please consult an attorney. You need to discuss all of this situation before you proceed to closing. The client didn't pay attention to that, but at least the agent had this email, so now the buyer cannot come against her because she actually told them and advised them to get an attorney. We deal with a lot of probate issues. Sadly, a lot of people passed away during Corona. And you may think that the person listing the contract has the power and authority to sell, but in reality, they don't. Until a probate is open and a personal representative appointed, they really don't have the power to sell the property or to even list the property. So if you're dealing with situations such as that, where you see that it's a person that passed away, have an attorney friend that, you know, I can be a friend and we can look at it and see, well, who has the power and authority to list this? And we may need to wait to list it until we have the personal representative appointed. It just depends. So it's so important. Anything having to do with contracts, if there's something that, even the minor question that you have, always go to the people that know, you know, the attorney, so that you can be properly advised and your client can be properly advised. And that way we minimize, I'm not saying you can avoid legal conflict, but this way you can minimize your exposure as an agent. I don't want you getting sued. Okay. Negligence, that's another thing that we see a lot. This is a cause of action alleging the failure to exercise due care towards others that a reasonable or prudent person would do under the circumstances. Clients can make claims that a real estate agent should have known something but did not and failed to take appropriate action. Negligence differs from fraud in that it lacks an element of intent. Often clients seeking legal action will begin by claiming fraud, but if they're unable to prove intent, they will seek reparations for negligence. It's hard to prevent claims of negligence because you might not always know what you should have known. Be sure to obtain insurance coverage for these unfortunate instances. In previous life, right, before Corona, agents were taking people left and right in their car, you know, showing them property. That has changed because of Corona. People kind of drive themselves. If you're taking people in your car, okay, it's so important that you have appropriate insurance, and it should be business insurance, right? It should be commercial insurance, because now you're using your car for business, and your regular car policy, it's not going to cover your client, and you don't want to be yourself responsible, right? So you want to make sure that you have appropriate liability coverage, appropriate insurance if you're taking people in your car, even if you're not. You always want to have as much insurance protection as possible so that in any scenario, you're additionally protected. this brings me to bodily injury, right? So if you're driving a client in your car and you crash, they will sue you. If a client is injured during a showing, oh, that one too. If you took them to a property and they fell there or something, they can sue you too. So if a client is injured during showing of a property and you're found liable, you will be responsible for reimbursing any costs related to the accident. Always make sure any debris is picked up. Bodily claims might also include physical problems resulting from an undisclosed mold problem. I've seen this one too. Client wanted to see this property. There was mold in the location, and they claimed that the realtor known or should have known and still took them there. And now they're trying to sue the realtor and the broker. So evaluate your property for all physical risks and protect your business with insurance on unforeseen accidents. What I would do is, and what I recommend my agents to do is have some type of disclaimer drafted, something that you make them sign that says that you're taking them to property, that you cannot make any representations regarding the state of the property, that they are assuming the risk of so many things, right? Like mold, animals, this and that, and that they cannot come after you or your brokerage and holding responsible. This is something that we can prepare for all the brokerages that will limit your exposure in the case of, bodily injury or things like that. Now, I understand that clients might be a little hesitant to sign, but it depends how you present it, right? So if you present it in a way that you say, this is how we do business, this is, one of our process that we have to go through in order to take you to see property, they might just do it. Just like before they just told you I want to go see property, now you're asking for a pre-approval or for a DU, you're asking for approval of funds because this is how we do things now. You can work it in so that way you can have additional protection, okay? It's all about protection. Failing to keep data secure. This is so important. If they're putting you in the middle between you and the bank, I can tell you from personal experience, the bank, they will ask for everything, including blood if they can. And when they put the agent in the middle, now you have to keep that data secure, okay? So hackers are everywhere, as we know, and they want your client's information. If they're successful in getting it, you will be the one who pays. Protect your client's information from criminals by installing security software and keeping your paperwork in a secure location. Once you have a secure system in place, regularly change your password and make sure your data is encrypted. This goes with everything. Hackers are all over the place. Before, what was really popular was the whole wire instruction things. You shouldn't be getting wire instructions for your clients. They should contact the title company directly. They should call the title company and verify by phone. So that way you are not responsible if somebody hacks into the email of the title company and gives you the wrong wire instructions. You try to limit your liability. And that way the title company is responsible. Of course, we are very responsible. We have a rule. All wire instructions need to be verified. You can't just rely on email anymore. Or the worst, please, sending wire instructions via WhatsApp. That can be hacked too. And it happens. And it has happened to really knowledgeable people who would think, they're fully secure. And it can happen to anybody, really. And the wire can be $10,000, $200,000, $300,000. So be extremely careful. Do not get yourself involved in providing wiring instructions. They can call the title company directly. Do not be involved in sharing documents with the bank or with the mortgage lender, with the mortgage broker. Have the client have that relationship directly with them. Don't get yourself in the middle. Again, I know it's hard because the clients are like, no, but you need to help me, this and that. Just explain that as part of your process and as part of your policy, and all of your brokerages should have policies and procedures. And if not, you can contact us to help you draft them. You're not allowed to be involved in obtaining personal information. You're not allowed to receive wiring information. And you're definitely, right, not allowed to be like the go-to person between the bank and the client. No. We don't want to do that. You want to limit your liability, put it as part of your policies and procedures, that you're not allowed to be involved in that. In the way you can go ahead with the transaction without assuming that extra liability. Okay, misleading clients, another lawsuit. So every real estate agent strives to make their property stand out from the crowd, and may even be tempting to exaggerate here and there about the features or condition of the house. However, this kind of deception can end disastrously for agents. If a buyer feels misled about anything, a lawsuit typically follows shortly after. Always be truthful about claims you make about a property with no room for misinterpretation. A misleading statement might help you close a sale, but it may also lead to legal action and financial loss. It's not worth the risk. So one way of misleading clients is by putting pictures that don't really reflect the property, that they're enhanced or this and that. Be careful with that. Don't do that. I mean, I have seen where you do renderings and things like that. It has to be fully disclosed. You don't want the clients to say that you misled them. Also, copyright violations. I mean, this is not here, but I'm telling you, it happens a lot. Don't use other people's photos. Do not. Use your own photo, because they may be using a photo that they didn't even take and they have no copyright on them, and then another person may have the copyright on them, but because you used it, now you're going to be held responsible. So be really careful with that. I know that there are systems through the MLS where you're allowed to basically market other people's listing, right? Be really hesitant of that, because when you market other people's listing, you are marketing it, your brokerage marketing it. So you are going to be responsible whether the photos that are there are copyright, regarding any statements made in the listing, in the MLS listing, that might be seen as discriminatory for some reason. So all those things, be extremely careful, because when you're marketing other people's listing, you're basically putting that information, publishing that information, and you're going to be responsible for whatever it says in the listing or whatever pictures they're using. Representing clients in unfamiliar territory. If you're showing and selling properties in an area that you're unfamiliar with, take extra precaution. Research first. Many times there are requirements or other situations, particularly to an area that you might be unaware. If an issue arises that is due to the geographic location, you may be blamed because you failed to warn your client about any such problems. For example, in the city of El Portal and in North Miami, you are required to get a reoccupancy certificate. If there's any construction there that was done without permits, we're not going to be able to close on that transaction. So just, just get familiar. Whatever territory you're going, maybe talk to a local agent there so that you're still able to get a listing there or sell a property there, but at least the client cannot come after you and say, well, you didn't know this, and because of your negligence, I ended up losing here and there. We don't want that, okay? We don't want to assume that extra liability. Giving legal advice, please don't. Have the client hire me, I'll speak to them, I'll give them all the legal advice they want, and many, many, many topics. So clients want the real estate agent to have an answer for every single question they ask. And real estate agents always want to help their clients. So just remember that it is considered illegal for real estate agents to give tax or legal advice. This mistake is especially difficult to avoid because taxes and legalities are, an unavoidable part of any real estate transaction. Give the wrong advice and the client will blame you for any consequence. Instead, politely request that your client direct any and all questions to me, an attorney, or to a CPA. This is so important. I know how it is, especially South American clients, because I deal with them all the time. They want their agent to answer everything, to know everything. Now, while it's good for you to know and understand and have a basic understanding of things that are involved in the real estate transaction, guide them, lead them towards an attorney that can answer the question and who can be legally responsible if they give the wrong answer, right? So every time I say anything, I'm responsible for what I say. If I give you the wrong legal advice, but I went to law school for this, this is my job, I should know what I'm doing. So it's okay, I can assume that liability, but there's no reason why you should. Okay, so let's keep going. Again, tips, please disclose everything that you know. Seller needs to disclose. Failing to disclose a property defect can lead to a lawsuit. What types of defects must be disclosed? Well, any material defect that threatens the property structure or interferes with the enjoyment must be disclosed. These defects include, but are not limited to, the following: permits or code violations, right? So the inspector must make sure the property is in accordance with the county regulation and possess updated permits. Any water issues, right? If during the inspection, buyer must be made aware of any water damage, problem with plumbing, non-working septic tanks, and more. Any structural issues during the inspection, buyer must be made aware of any, shoddy remodeling or construction, underlying structural problems not readily observable, and any wiring and electrical issues. If you don't know, you don't disclose because you don't know. If you know, you have to disclose, because nothing is hidden under the sun, and it will eventually come out, and it will come out by the seller. The seller will say, but I told my agent this, and she told me, or he told me it was okay, I don't need to disclose that. Do not. If your seller wants to know whether he or she is required to disclose something, have them call me. Let's discuss, let's analyze the law, let's discuss the potential liability and potential exposure, and then the seller can make their decision, okay? Have them do the seller disclosure. This I've seen too, please don't do this. the seller's like, oh, I don't want to do a seller disclosure, you do it for me. So here's the realtor doing the seller disclosure, putting, I don't know, no. Guess who's going to be responsible? The agent is. If you're the one filling it out, no. The seller needs to be filling out the seller disclosure. If they don't know, they don't know. And if they know, they need to disclose. Don't get involved with that, because that's also assuming liability on your end. And for you guys that are brokers, please tell your agents, whenever they get sued, they're going to sue you too. So you want to make sure you have proper policies and procedures where we are basically thinking about how to avoid liability with every action that we take. It is extremely important. All right, so be proactive, address your client's concerns timely, right? So understand your duty to each party depending on the relationship that you're on, whether you're a transaction broker or a fiduciary, understand it. Make sure all necessary parties sign the contract. This is so important. That is something that you should do. If you are sending in an offer, right? Okay, so actually I see these two of them. If you're sending an offer and everybody signs, we're done. That's a contract. If you're sending an offer and they reply back and they make a change and they didn't initial that change, it's not a contract until the other party initials that change. So what is that? It's a counter offer. So I had a situation where that is exactly what happened. Offer was sent, seller made some changes, the buyer never initialed those changes, and the agent incorrectly believed that because the buyer never initialed those changes didn't apply to the transaction, but we can still proceed to closing. As soon as I got the contract, I'm like, no, this is not a contract. This is an offer. An offer was sent. We have a counter offer, and the counter offer was never accepted. The seller went and sold it to somebody else. Can they legally do it? Yes. And then the buyer, what did they do? Blame the agent, of course. If there is an offer is sent and any changes are made and it comes back to you, those changes need to be initialed by the other party for there to be a contract. This applies to any contract. I've had situations in other instances as well, not just in the real estate arena. Any contract, whenever an offer is presented, the other party can accept it, sign it, we're done. If they make any changes, I don't care how little they are, they will initial them, send them back to the beginning party. If the beginning party doesn't initial those, there is no contract, right? And it doesn't mean that you could enforce all the other terms that were agreed to, except those. It doesn't mean that. It means there's no contract. It was an offer, counter offer, never accepted, no contract. So that applies to any transaction, okay? So any changes need to be initialed by both parties. Again, understand who the parties to the contracts are, right? So their real name, they need to be properly identified. If it's a Florida LLC, because you could have the same name of an LLC in Florida as in Texas, you want to make sure who you're getting into contract with. You want to manage deadlines and meet all milestones. I really like it when the agents send a little list of the deadlines. If you have any questions regarding deadlines, ask the attorney so that we can look at the contract and see what applies. Failure to extend the contract once it has expired. I think most of you guys know this already, but if you extend the contract, doesn't mean you're extending the financial contingency. You want to make sure that you're extending both if the client is buying with a loan. Otherwise, extending the contract doesn't really do anything if they're not able to get the loan after the financial contingency. Failure to perform a walkthrough prior to closing, please do that. Have them do a walkthrough. This is so important. Leases, if you're buying commercial property or a duplex or a triplex or a fourplex, make sure that those leases are assigned. It's, you know, and I see this too. This is failure in the title company as well. I mean, like some of them are not attorney run, because what happens is you buy the property, but legally you don't have the right to the leases because those were never assigned. And you want to make sure that you obtain tenant stopples to know how much deposit does the tenant have, you know, what issues that they have. There's so many things that can come up when you buy a property with leases. You can't just rely by looking at the existing lease, because the tenant may have a whole different idea. They may not have paid in 4 months and you won't even know. So you want to make sure that all of the leases are reviewed and the leases are assigned and you obtain a tenant stopple. So that way, I mean, the title company attorney should be doing this, but you know, make sure that it gets done. So that way the tenant cannot say, well, I used to pay this amount of rent, why are you charging me more? And of course, watch out for reoccupancy certificates. Certain cities require, like El Portal, North Miami. And when they require a reoccupancy certificate, guess what? If you did an illegal construction, that's going to be an issue. Okay, so plan ahead. Again, of course, always try to de-escalate. If you sense or know of an impending lawsuit, act immediately, contact an attorney right away so we can discuss a possible settlement or see how we can defend it. Consider getting professional liability insurance. It could be errors and omission. This will help you diminish the financial liabilities burden and any possible suit. And protect yourself, all right? So every time you are doing business, you're basically imagine going into I-95 and little cars are coming at you and eventually you're gonna get hit. We're all gonna get sued eventually. One way that we can protect ourselves is by operating under a company, because that way they can only attack the assets that the company has, but they cannot attack your personal assets. So what is my recommendation? As real estate agents, you are considered professionals. Yes, yes, yes. So you can be a professional association, which is basically a corporation that takes on that designation, or you can be a professional limit liability company. You can be that as well. So what do I recommend? I recommend forming a corporation that is designated as a professional association. The reason that I recommend that is because if you're going to operate under a company, the regulations allow you for you to do that, but you can be the only owner. So you cannot have a company that you're using to receive your real estate commission and have more than one owner. They do not allow that. So you need to be the owner 100% of your company, and then you would receive the commission under that company. The laws changed in Florida in 2015. There was a case, it was called Olmstead, and then it became, actually they redid the statutes. So single member LLCs don't offer you the same liability protection as a multi-member LLC. And because as a realtor, you could only operate under an LLC that has one owner. That is why I do not recommend operating under an LLC, a professional limited liability company. I recommend forming a corporation, okay, which is designated as a professional association that will give you separate legal entity from the owners. So whatever the corporation has, that's the only asset they can attack. You will have limited liability. We can file for something called S-corp status for the corporation, so that it's passed through taxation. So the corporation, it's only really, you only pay taxes once. The corporation passes all of the losses and the gains to you in your personal capacity, and you put it as part of your tax return. So that's also a benefit of being a PA. You can file for S-corp. Now, it does require yearly and board meetings, the professional association, but we can help with that. So don't worry. Once you hire us to form your PA, every year we serve as registered agent and help you do the corporate documents so that you're compliant. And it protects your personal assets. That is so important. So real estate agents should consider becoming a professional association. Though this will not keep you from getting sued, it can minimize the effect on your personal finances, right? If you should ever receive a lawsuit. And there's also tax benefits if you set up properly. So why do I recommend most real estate agents to choose a PA or professional association? It's less expensive. DBPR, right, the Division of Professional Regulation, allows you to change your individual real estate license into your PA. Now, the name that you can use for your PA, it's your legal name. So if your license right now, for example, my name, right? Let's say I had a license and my license is Romy Jurado. The name of my PA can only be Romy Jurado PA, because they will not give you a real estate license in a creative name that you come up with, only your legal name, okay? And why would I choose a PA? Well, it's going to give you more protection, right? From fraud, breach of duty, breach of contract, negligence, bodily injury, property damage, misrepresentation regarding the condition of the property, some Consumer Protection Act, earnest money dispute, misrepresentation regarding flooding, leaks, and misrepresentation regarding the value of the property, because all those lawsuits have to go towards your PA. And your PA, the only money that they're going to hold is the commission. So they're going to receive commission from the brokerage, give it to you so you can use it personally. So there isn't going to be any assets. You should not be using your PA to buy property, to do anything like that. You should only use it for your real estate commissions. So that way, if there was ever a lawsuit, that's the only thing that they could attack. So the corporate veil, I'm sure you've heard this before. Once you incorporate, you are now considered an entirely separate and prominent distinct entity in the eyes of the law. Both you and your company are granted rights under Florida law. These laws not only grant your company rights, but protect them as well by what is legally referred to as the corporate veil. The corporate veil is a legal concept that separates the personality of a corporation from the personalities of its shareholders and protects them from being personally liable for the company's debts and other obligations. So lawsuits, debts, all those things are going to be protected. So here's a little package that we put together to help real estate agents file that PA today. Here are the usual prices, right, that we would charge. However, for realtors, because I love you guys bring us business, you are always able to get a little discount from us for your PA, and we can only charge you, we'll charge you $650, and that includes the state filing fee, obtaining your EIN or tax ID. It includes us helping you file or fill out the form for you to be an S Corp. It includes the register agent fees. I will serve as register agent in the state of Florida. We will help you fill out the form to send to the state so that your license can come up in the name of your PA. We will prepare your corporate documents, and of course, it includes our attorney's fees. So all of that, we give you a discount. You only pay $650, and of course, every year you have to renew your PA. All right, so there we are. If you have any questions regarding today's presentation, please put it in the Q&A. I don't see any questions yet. You could also put it in the chat. I put in my contact information, and let me know. Let me stop sharing my screen. 1 second. Okay, perfect. I don't see any questions. Oh wait, somebody raised a hand. Can you put it in the chat or in the Q&A, and I will gladly answer it? Okay, well, okay, let's see. Hi, Romy. Hi. I have current an LLC. Does it make sense to switch to a PA? If you're operating under your license under an LLC, it does make sense to switch it to a PA because you're going to have more liability protection, and it's just better for you to operate under the PA. That is my legal advice. So I would absolutely, and have your license under a PA. And this goes for any business venture that you go into. Single member LLCs in Florida, okay, I'm only talking about Florida, other states are different, don't provide as much liability protection. So my advice is add somebody else that you trust, even with a 1%, so that you make it a multi-member LLC, and then you do have that legal protection that we want to get from operating under an entity. Now, we could also lose that protection if you start using the company's bank account as your piggy bank. You're not supposed to do that. You can take money from the company's bank account as distributions or salary. You also want to use your company's bank or credit card or bank account for legitimate business purposes, depending on the business that you're on. So that way they're not, they cannot use the fact that you use the bank account for personal things to basically get rid of your corporate veil. Just working under an entity doesn't mean they cannot sue you personally. It means you're going to be protected if, 1, you follow corporate formalities, 2, you're not using that bank account as your personal piggy bank. So be really careful with that, and that applies for everything. Somebody's asking me, can I speak instead of writing? I think so. No, actually, no, it doesn't allow me. I'm sorry. I never have. So if you can write it, or if not, you can call me after. I'll gladly answer it or try to write it. That would be fabulous. Oh, one more lawsuit thing that I forgot to mention that I've seen it a lot. Section 8 housing. If somebody is reaching out to you via text message, WhatsApp, Instagram, Facebook, asking you, do you accept Section 8 people in your lease, for your lease property? Can you accept Section 8? The answer is yes. Okay, the answer is yes, because you do, because you cannot discriminate. All right, they can submit their application, and then the landlord has free will to decide who to rent or who not to rent. But the answer is always going to be yes, absolutely. Let's set up a time to look at the property. Don't ever answer no, because that's it. Just that no, lawsuit. And I have seen this lawsuit all over the state of Florida. There are law firms out there that are sending out testers. Basically, you're going to get these text messages on Instagram, on Facebook, asking you, or they're going to call. And all you need to say is no, and then that's it, lawsuit. Okay, and these lawsuits are very hard to defend because that's per se discrimination. So be really careful. If somebody asks you about that, the answer is yes, absolutely. All right, I don't see, here we go, one more question. What kind of protections do you recommend for agents when hiring professional photographers? Oh, this is such a good question. We require a photography agreement, but photographers will often push back even though the document is directly from NAR. Is there anything else you recommend to ensure the photographers are granting agents permission to use their photos on the MLS? This is so important. So basically, when you hire anybody, a photographer, a website provider, anybody that creates something for you, even if you're paying them, it does not mean you own it. It does not. It's not automatic. You need to have a contract that has that assignment of rights. You need to have this magical language that's called work for hire. Work for hire is a doctrine that says that you hire these people to do whatever it is you have them do for the benefit of you, and the rights should belong to you. And of course, the assignment of intellectual property. It is so important because that's another lawsuit that I see a lot. Okay, you get somebody's photo, even from Google, and it says that you can use it, but very in the bottom it says no, you can't unless you have attribution, and then boom, they try to sue you for copyright violation. And the photographers, I mean, listen, if they create it, they own it. So unless they sign an assignment for you and they have this magical language of work for hire, you don't own those pictures. Even the photographers at a wedding, I actually had a case like that. Photographer went to take wedding pictures, and now they were using those pictures to promote the photography services. And the bride was so mad about it, came to us, Romy, what can I do? I don't want him using my pictures. I looked at the agreement and there's nothing they can do because the photographer took the pictures. They own those photos. You don't. So this applies in any scenario where people are creating stuff for you. There has to be an assignment of rights, and there has to be that work for hire doctrine mentioned within the contract. All right, somebody else is asking, I have an older client that doesn't use email. Everything is verbal. What do you recommend for this? How can I prove what I said or that? Okay, so in Florida, it's illegal to record somebody without their authorization. Okay, so if they're not authorizing you to record them, you cannot. However, if you say, my name is so-and-so, I'm asking to record X person is agreeing to be recorded. Do you agree to be recorded? Yes, I do. Okay, great. Boom, then you start talking. Now you have proof of what you said to that person. Do I recommend doing that? Yes, since you cannot put it in writing. Absolutely. If you can videotape it, even better, right? But you have to get authorization. You have to say, my name is this other person is authorizing me to record them. Are you authorizing me? They have to say a clear yes. Perfect. Now you start talking and saying whatever you need to say. It's illegal. Let me say it again. It's a crime to record somebody without their authorization. Okay, you cannot in the state of Florida. In other states, maybe, not in the state of Florida. So that is why you have to get consent in order for you to be able to use it. And I would if I was in your situation. So that way you're protected and they cannot say that, oh, well, you didn't tell us this. Yes, I did. Oh, no, you cannot use it in court. Oh, yes, I can because you authorized me to record it. So that's what I would do. Any other questions? No? Okie dokie. So I want to thank you all for attending my class today. I'm hoping we can do live classes soon. I missed them. I did one yesterday and it was a lot of fun. So I hope to see you all. If there's any other question that you need to ask me, feel free to reach out by email, by phone. My contact information is in the chat, by Instagram, Facebook. I love working with realtors. You guys are amazing and we can help each other out. We can grow our business and protect our business from lawsuits so that what we work so hard for doesn't just get taken. Thank you so much. Thank you for attending today's class. Bye.